Federal cannabis law is not as settled as many people think, and recent signals tied to Donald Trump are raising new legal questions. Today, we're breaking down what's actually changing, what isn't, and why this matters specifically for Virginia. Over the last several election cycles, cannabis policy has become a political talking point at the federal level. While many states, including Virginia, have passed their own cannabis laws, federal law still controls enforcement priorities, banking access, and interstate activity. Recent commentary and policy signals connected to Donald Trump have led to confusion online, especially claims that federal marijuana laws are about to dramatically change. So let's slow this down and look at the legal reality. First, it's important to understand this. Cannabis remains a Schedule I substance under the Federal Controlled Substances Act, unless Congress or federal agencies formally change that classification. A pivot in tone or messaging does not automatically change the law. What can change under a presidential administration includes federal enforcement priorities, DOJ guidance and discretion, agency-level review processes, political support or opposition to congressional reform. What cannot change without legislation? Federal legality, interstate commerce rules, federal criminal statutes, banking law restrictions. Any discussion of federal reform must pass through Congress or formal agency rulemaking, not campaign statements. Virginia-specific impact. For Virginians, this matters because state cannabis law exists within a federal framework. Virginia's medical cannabis system operates legally under state law, but federal law still affects banking. Federal property rules still apply. Interstate transport remains illegal. Employment and firearm rules remain federally influenced. Even if federal rhetoric shifts, Virginia enforcement, zoning, licensing, and compliance rules do not automatically change. This is where misunderstandings can create serious legal risk. Who this affects? This impacts Virginia medical cannabis patients, healthcare providers, local governments and zoning boards, employers navigating compliance, anyone assuming federal approval equals legal safety. Legal clarity matters more than political headlines. Why this matters? We've seen cycles before where expectations ran ahead of the law, and people paid the price. Understanding the difference between political signaling, administrative discretion, actual statutory law is essential if you want to stay compliant in Virginia. What to watch next, legally framed. The real indicators to monitor are congressional bills and committee movement, DEA scheduling reviews, DOJ enforcement memos, Virginia legislative responses. Not viral clips. Not campaign promises. So here's a community question. Do you think federal cannabis confusion is making compliance harder for states like Virginia, or is the uncertainty intentional? Drop it in the comments. Please like, comment, and subscribe for more videos like this. For deeper legal discussion, you can read the full breakdown and join the Norfolk City Cannabis Community to continue the conversation.